To Bianchi Law Talk. Bob Bianchi here. Firstly, thank you all for the tremendous support that you have given me with regard to this project. I appreciate you liking the Bianchi Law Talk Facebook page, and down below there's a description as to a YouTube link that I'd ask that you'd also join on YouTube, as well as Bianchi Law Talk if you haven't already joined. And we really appreciate the shares too. So we've gotten some amazing questions by people based upon these informal talks that I'm giving, based upon my many years of experience as an assistant prosecutor, the head county prosecutor, as well as now and often before a criminal defense attorney. So I've kind of got it from all perspectives. And myself and my partner, law partner, David Bruno at the Bianchi Law Group are very honored to represent the clients, especially on this topic. Many of you have asked kind of variations on the same theme. I was going to do a different topic, but I decided let me try to bite this one off. I've gotten questions about, can you define harassment for us, or cyber harassment, or the harassment, intimidation, and bullying? Hey, for those adults that are out there, this is a great topic because it both affects adults and children. We have a plethora of cases as prosecutors that we dealt with this area, as well now in our criminal defense practice, also especially related for adults in the domestic violence context, harassment and cyberbullying, as well as kids with the never-ending and relentless torment that sometimes children can visit upon other children that have had some extremely tragic consequences. We're seeing the age of suicides with children who are the victims of the scourge of bullying, cyberbullying in particular, on the rise, and it's really sad. We've had some cases in Morris County that both as prosecutor and afterwards were very heart-wrenching. And I think that it's worthy of noting that this explosion of cases in the harassment, cyberbullying area has come about as a result of the computers and social media. And people it seems to me, to be impervious to the idea that what they're doing and what they're saying can somehow have criminal law consequences. There seems to be, based on my experience as a prosecutor, as a defense attorney, and in the media, this sentiment, this feeling going on in the world that I can say whatever I want, whenever I want, however I want, to whomever I want, without any consequences, and they will often jump to the First Amendment right to free speech. Wrong. Your speech is not completely protected. It's jealously guarded, as they would say, under the law. But there are times where your speech can cross the line and you can wind up into the criminal law context. And what I saw as prosecutor, is parents who aren't educating their kids get into these cyber crime scenarios, and then they seem to be offended when they never went to lectures, they never listened to tapes such as this, they never educated their kids, they crossed the line, victimized another kid, and this is being taken very serious in the law enforcement community, so I think that you should show this to your children. First off, let's go to some definitions here because it's very confusing. There are multiple statutes that deal with speech and how speech can become criminal. There's 4 in particular that we deal with all the time. The harassment statute, which is different from the cyber harassment statute, which is different from the harassment, intimidation, and bullying statute, which is different from terroristic threats. This is a big conversation, folks. It takes experts years and years and years to learn not only the law, but the cases, but it's important to understand the definitions because then you'll be able to put into context what your kids are doing to determine whether or not it's crossing the line. And yes, you should be watching what your kids are doing, not only for their safety, but to ensure that they're not victimizing anyone else. So let's start with the harassment statute. This statute's been around forever. It's just called harassment. Excuse me for looking down, but I got my cheat sheet here and I want to make sure I get it right. And also note the level of severity of the crime for each of these things. I'll go over that. Harassment is where a person commits a petty disorderly person's offense if with the purpose, this is very important, this is why it's constitutionally allowed, it's with the purpose to harass another, A, makes or causes to be made a communication or communications anonymously or at extremely inconvenient hours or in offensively coarse language, and here's the one where we're always debating it in court, or any other manner likely to cause annoyance or alarm. That's a really big concept, and that's usually where we're having the arguments. is multiple and repeated texts to the new girlfriend or the new wife. Does that get to a point where it's likely to cause annoyance or alarm, or what is being communicated or how it's being communicated? And it essentially comes down, one, did the person who is sending this social media message out or text message have a purpose to harass? That saves it constitutionally. And it has to be your goal to want to harass a person, not just express your anger. That's not harassment. And is it done in a manner that's at inconvenient hours, offensively coarse language, or any other manner likely to cause annoyance or alarm? The other part of the section of the statute that's relevant there is any other course of alarming conduct or repeatedly committed acts with purpose to alarm or seriously annoy such person. So where we have, this always comes up in the domestic violence cases, whether or not they're splitting up or there's boyfriend, girlfriend splitting up, or there's someone third party that comes into the relationship. It may not necessarily be a crime or a purpose to harass by sending a message or two. But when you have some, like I've seen, where there's 1,300 messages going out or all hours of the day and night, that may then move it from what is protected constitutional speech into a harassment scenario. So that's the simple harassment statute, and it's only a petty disorderly person's offense. That's the lowest level of offense you can get under the law. But if you have a license to practice more of a lawyer, doctor, or engineer, or a police officer, or one of those things, this could have consequences to your job. And this is the thing that nobody thinks about until it happens to them. Or if you're a kid, you've got this on your record. If you're over the age of 18, but even if you're under the age of 18 and it's sealed, certain professions, people think that it's sealed and nobody ever sees it. That's not true. Certain professions are allowed to look into your record when you become an adult, so be very careful with harassment. The other one is cyber harassment. Cyber harassment is a completely different crime. It came out only a couple of years ago. And cyber harassment is when a person commits cyber harassment if while making a communication in an online capacity with an electronic device to a social networking site with the purpose to harass another. Again, that's what saves it constitutionally. That's why your free speech can be limited if with the purpose to harass another, one, you threaten to inflict injury or physical harm to any other person or property. It's not just a person now, it's property. And knowingly sends, posts, comments, requests, suggests, or proposes any lewd, indecent, or obscene material to or about a person with the intent to emotionally harm. It's one of the few statutes I've ever seen where that emotional harm rather than physical harm comes out. That a reasonable person, place, or person would be in fear of physical or emotional harm to his person. That is the cyber harassment statute. Both adults and children can be convicted of that cyber harassment crime, and it's separate. It's a fourth-degree offense. And here's another part of that statute. If you threaten to commit any crime against the person or the person's property, I'll mess you up, I'll break your car into your car, I'm going to punch you in the nose. You're in the cyber harassment world where your protected speech, remember you can't yell fire in a crowded movie theater, your protected speech is in serious jeopardy there. And believe it or not, we actually have a section of that statute that makes it illegal for a person, it's a crime of the fourth degree, by the way, which is up to 18 months in state prison if you're convicted. But there's also a section of the statute that says a person is 21 years of age or older at the time of the offense and impersonates a minor for the purpose of harassing a minor. Yes, we have adults that actually engage in this behavior. They pose to be a minor, harassing a minor online, and that is a crime of the third degree, which goes from 18 months in state prison on a fourth degree. Third degree crimes are 3 to 5 years in New Jersey state prison if you are convicted of that. So you need to be careful with regard to what you or your children are posting online. Despite how angry you may be, it may fit within the harassment or cyber harassment world. I'll take one little sidebar here. If it's really bad and you're using an electronic device like a phone or a computer, you could be in violation of federal law because that is what they call an interstate facility. So be careful with that. The third area of speech that people seem to think they're protected from is terroristic threats. But what is a terroristic threat? You can't use layman's definitions here, folks. That's why I'm giving you these definitions. A terroristic threat is a person is guilty of a crime of the third degree, which is 3 to 5 years in state prison, if he threatens to commit any crime of violence with the purpose to terrorize another, cause evacuation of a building, place of assembly, kids calling in bomb threats, things of that nature, or cause evacuation of a transportation facility, or otherwise cause serious public inconvenience, or in reckless disregard of the risk of causing terror and inconvenience, so it doesn't even have to be purposeful. And a person is guilty of a crime of the third degree if he threatens to kill another person with the purpose to put him in, and here's the important language, imminent fear of death under circumstances reasonably causing the victim to believe the immediacy of the threat and likelihood that it will be carried out. So let's say you have a scenario in which somebody in one state is saying to somebody in another state, these are cases we've actually had, so I'm not making them up. I don't need to make it up. We deal with this every day. Hey, I'm going to go over there and I'm going to kill you for what you did. That probably would not be a terrorist threat because of the language I just read to you. Has to be in imminent fear of death under circumstances reasonably causing the victim to believe the immediacy of the threat. However, if I'm standing with a knife in my hand or a gun in my hand and I make the threat, I'm going to kill you, you are in the land of terroristic threats. The last section of speech that is not protected, that people seem to think is with the harassment, intimidation, and bullying statute. Now, this was dear to my heart as the prosecutor. We were doing bullying lectures throughout the county prior to it becoming quote-unquote fashionable, and we worked with the education community very hard, but then the law came into effect. It's probably the most powerful law that's out there with respect to harassment, intimidation in the school setting. What does that harassment mean? It's different than the regular harassment statute I just read to you. It reads differently than the cyber harassment statute that I read to you, and differently from the terroristic threats. So here's how it reads. Harassment, intimidation, or bullying means any gesture or written, verbal, or physical act, or any electronic communication, think of your kids here, whether it is a single incident or a series of incidents that is reasonably perceived as being motivated either by any actual or perceived characteristic, characteristic that is reasonably perceived as being motivated either by an actual or perceived characteristics such as race, color, religion, ancestry, national origin, gender, sexual orientation, gender identity and expression, or a mental, physical, or sensory disability, or any other distinguishing characteristic that takes place on school property or a school-sponsored function or on a school bus or off school grounds as provided for, and there's some off-school grounds becomes a little bit of a scenario that you have to deal with as to whether that's actionable under the statute, that a reasonable person should know under the circumstances will have an effect of physically or emotionally harming the student and putting the student in reasonable fear of physical or emotional harm, and on it goes. So what this statute was intending on doing was making sure that the education community was taking very seriously these things, capturing the complaints, also making sure that they're properly investigated. And here is a real practice point that very few people know unless you're in the position that I was in as the prosecutor, who was responsible on the law enforcement side of making sure the harassment, intimidation, bullying statute was being implemented. And this is the problem that we have with our schools. And I saw it for the 6 years that I was the head county prosecutor. Some schools are very, very good at reporting incidents of criminality occurring within their campuses. Other schools don't play so well in the sandbox. And those individuals sometimes do not alert law enforcement with respect to drugs, sexual activity, or sexual assault, and or harassment. And what would bother the schools that were properly reporting was that, well, it makes us look unsafe because we have to report these statistics, and the other school isn't following the law, and it's not only a danger to their students, but it's making them look like they're a safer school. This is the conundrum that law enforcement deals with in the implementation of the harassment, intimidation, and bullying statute. Now, to be sure, most places would like to prevent those things from happening. But remember, there's rights that are given to defendants in the harassment, intimidation, and bullying statute. There have been instances in which people have used it inappropriately in order to gain advantage. I'll give you some examples. In order to have people thrown off the football team or thrown off the cheerleading squad, and they file a bogus harassment, intimidation, and bullying charge. I find this to be a scourge and a really bad thing that should be actionable, because what they're doing is taking away the legitimacy of those many students who are being taunted and tormented by other kids and deserve the protections of the harassment, intimidation, and bullying statute. So there you go, folks. 4 areas of speech that can be restricted, and for which 3 of those you could have actually committed an offense or a crime. And let me just indicate what I noticed also with parents in schools. The victim in the cyber harassment scenario, I know it's cliche to say, but it's really true, has no refuge. It's not like the schoolyards when we were kids and you may get in a scrap and you can kind of avoid a certain area where somebody's bullying you at. It is a 24/7, unrelenting, many times herd mentality of constantly battering and beating people up, these poor kids. And you know what? I want to just say to you, when I started going to law school, and I think this is important for parents to know, the law is the lowest level of acceptable behavior in a society. It is not something you should aspire to. It's what's the least level of acceptable behavior. We should be aspiring to make sure that our kids are not harassing or intimidating and treating people with respect all the time. But in the criminal law world, when you violate that, these kids don't realize the collateral consequences. And these bullies, on the other hand, they don't see the damage that they're creating. And many times in the anonymity or not even in the anonymity of just people using social media the way they do, you all know what I'm talking about. You can kind of go overboard with things because you're not directly in front of a person. So it's even difficult for the bully to even know where to stop. Not that I'm sanctioning what the bully is doing. The parents and the bully should not be bullying, but nevertheless, the computers have become as great as they may be, they have created a lot of problems for kids. So folks, that's about as far as I can go with regard to the definitions of these things. I see this in the context of domestic violence cases for adults all the time, matrimonial actions, dating relationships. People go over the line and wind up charged with an offense or a crime, and then you're calling a guy like me at the Bianchi Law Group or my partner David Bruno, and you're shocked that your speech could be criminalized like this, and it can be. And in the school context, there are significant repercussions for people who are investigated and found guilty of, if you will, of having violated the harassment, intimidation, and bullying statute. Which gets me to the next point. Not all conduct, however, is harassment, intimidation, and bullying. You have scenarios, I'm sorry it's difficult. I see people are asking me to answer questions, but on my phone, I'm just unable to do it as the next person is. Keying in there. Unfortunately, if you want to send me a text, feel free. Well, that won't work either. Don't send me a text. I'm on the phone. But with respect to what we're doing here, not all things that are said are criminal or harassment even. I read you those definitions. Sometimes people are just mean-spirited, angry, saying hateful things, which gets me to why you see this Bianchi Law Talk page has motivational speaking on it. It may sound odd to you. Well, based on those experiences I had as the prosecutor, I have lectured throughout the country and outside of the country on how to build resiliency. I've done that with respect to started out with law enforcement agencies, and then my good friend Angela Kubisky, who's, I can't scroll Angela in the scenario I'm in right now, is a person who brought me to the Morris County Chamber of Commerce with regard to young business professionals. And then it just exploded into educators and individuals who asked me to lecture bar associations throughout the country. Why do I do that? Because I think it is important that people build resiliency skills. Not everything is going to go your way. How could we lead a joyful journey? I'm going to put some content on there as we go forward on this website. But for right now, I'm going to try to real quick go on to the Bianchi Law Talk to see if there's any questions I can answer that I can actually see on the computer, because I can't see it on my phone, and I know people are asking me questions. I will in the future try to come up with a scenario that that deals with that. Unfortunately, it's just not. Well, let me just give me a second, folks. I apologize. hopefully I don't see them here, unfortunately, on my computer either. Angela asked me to scroll down. I do everything Angela tells me to do. And here we go. Can you remark on the kids that do not bully, but they are being accused and investigated? That's a great question. I'm glad I scrolled down. There are, like I said before, which I believe is where Angela's comment is coming from, there are scenarios in which kids are falsely accused. They have due process rights under the harassment, intimidation, and bullying statute. They have a right to discovery. They have a right to defend themselves. Just like anybody who would be falsely accused of a criminal offense. That is happening, and I believe that the schools should take that very seriously if it's later determined that an individual has inappropriately used the intimidation and harassment. You probably, in some instances, would have to get a lawyer. I think that that's always the best way to do it, because a lawyer is going to know how to read the law, how to go about investigating it, and how to go about defending the child against the false accusation, and false accusations do occur. Thank you, Angela, for that question. I'm glad I scrolled down. I apologize, it got a little choppy there in the end. Hey, folks, listen, I thank you so much from the bottom of my heart for the great questions that you're bringing in. For those of you who support the Bianchi Law Talk on Facebook, I'd ask if you haven't joined and somehow you're watching this, that you please do join. I have a link at the bottom of this that you can click on for Bianchi Law Talk, as well as please join my YouTube channel. I have a link there, Robert Bianchi ESQ, and in Instagram and Twitter at rbianchiesq as well. And I'd ask that you share. If you find these messages are important, share this with your family and friends. It'd be greatly appreciated, as always, for those who support the Bianchi Law Group and myself and my partner, David Bruno, with the cases that we have the honor of representing individuals who get themselves into trouble, either in criminal court or domestic violence or municipal court. We always appreciate those referrals. So I'll be doing more videos during the week, but I'll be back again next Sunday at 10:30 a.m. Keep those questions coming in, and hopefully I'll be able to answer one of those for you. Thank you, and have a great week, guys. Bye.